I will be looking at the issue of animal personhood from a distinctly legal theoretical point of view. My objective is not to determine whether animals are persons in some kind of metaphysical sense, but whether animals can be made persons in specifically legal terms. But first, why is legal personhood for animals an important issue? The case for legal personhood has become particularly relevant in light of the catastrophic failure of traditional animal protection law to redress the fundamental injustices underlying the human-animal relationship, or even to fulfill its very modest purpose to protect animals. Many scholars have identified the object and property status of animals as one of the major reasons for the inadequacy of animal protection law. This instrumental status of animals is a direct reflection and a powerful multiplier of the persisting objectification, commodification, and instrumentalization of animals. It is also the principal legal impediment to acquiring rights for animals. Our legal system, as most of you might know, is based on a dualistic divide between legal subjects or persons on the one hand, and on the other hand, legal objects or things, which are property. So the opposite of and the only tangible alternative to being property is to be a legal person. Personhood would not just symbolize but institutionalize the inherent value of animals and would serve as a gateway to fundamental rights analogous to human rights. And it would provide a crucial legal starting point from which to emancipate animals from the oppressive conditions they are forced to live and die in, or as the critical theorist Max Horkheimer calls it in his skyscraper metaphor, from animal hell in human society. So, having summarily indicated some reasons why animals should be awarded legal personhood, let me now turn to the primary issue at hand, the legal theoretical question whether animals could be legal persons. Starting from the status quo, the proposition of legal personhood for animals has a difficult stand. The current legal situation is such that only persons have rights, and there exist only two kinds of legal persons: the natural person, i.e. humans, and juristic persons, for example, corporations and sovereign states, etc. There is no third, tertium non datur. Since animals are neither nor, they are not persons and therefore cannot have rights. Furthermore, the prevailing view of legal scholars is that animals are not and cannot be persons, since this term solely pertains to humans as rational beings. Accordingly, the standard argument against conferring rights to animals asserts that only persons can have rights and animals are not persons, hence animals cannot have rights. So this negative assessment of animal personhood and animal rights derives from the traditional humanist view on personhood, which quite roughly and oversimplified, subscribes to the following formula, which you can see here: humans equals persons equals rights. So that means, owing to their rational nature, all and only human beings are persons and thus have rights. So considering this starting point, the concept of personhood does seem rather unsuitable for animals. Indeed, the traditional concept of personhood is defined in human-centered terms and built on the idea of the animal as the antithetical other. However, theoretically, the concept of legal personhood can be interpreted to be applicable to animals. A common approach is to extend the existing concept of personhood to animals who suit its anthropomorphic profile, by asserting that some animals are cognitively similar to humans to such an extent that they actually are persons and should be recognized as such. This similarity approach or sameness approach, which has been mentioned priorly already, typically singles out a few sufficiently human-like animals and places them within the realm of traditional human-centered personhood. So I would like to pursue a different approach, one directed at re-examining and redefining the concept of legal personhood so as to expand its normative scope to include a broader range of animals. I would like to begin my examination by referring to Steve Sapontz's distinction between the descriptive and normative meaning of personhood. In the descriptive sense, person denotes a being which displays certain qualified cognitive traits. These characteristics range from agency, autonomy, self-awareness, morality, intentionality, to language, etc., or in short, rationality. So I will be using rationality as a signifier for all of these characteristics. So even though descriptive personhood does not explicitly refer to species and merely describes rational beings, the relevant criteria are typically reflective of those properties which are presumed to be genuinely human, which renders the concept in itself rather anthropoid and exclusive of animals. So in the normative sense, personhood assigns a certain status and is employed to identify the value of certain entities. Being a person in the normative sense means being due respect as an end in oneself and having one's interests protected through rights. So the term person is thus ambiguous and can be either used to describe beings who are persons or to allocate rights to beings who are normatively deemed persons. So this differentiation has an illuminating effect on the standard argument against animal rights, which I have already mentioned, and you can see here on this slide. It can now be specified to be claiming more precisely that only persons in the normative sense can have rights, and animals are not persons in the descriptive sense, so hence, or not hence actually, animals cannot have rights. So obviously this argument equivocates by using two different meanings of the term person and lacks further justification as to the relationship between the descriptive and the normative sense of personhood. Likewise, the formula humans equals persons equals rights conflates the different meanings of the term person. What it actually says is that humans equals persons D, or persons in the descriptive sense, and rather unrelated that persons N, so meaning persons in the normative sense, equals rights. So giving the argument the benefit of the doubt, it could imply that that being a person in the descriptive sense is a necessary condition for being a person in the normative sense, so that the relation between the two senses of personhood is one of identity. So what I would like to examine now is whether this amended formula, humans equals persons D equals persons N equals rights, whether this formula can be sustained when further scrutinized. So the claim that personhood in the descriptive sense is a necessary prerequisite of personhood in the normative sense can be easily contested because it defies reality. As the argument from marginal cases has abundantly pointed out, not all human beings are in possession of the cognitive capacities which distinguish persons in the descriptive sense. Nonetheless, all human beings are legal persons. Furthermore, as cognitive ethologists have demonstrated, some animals possess cognitive capacities which exceed those of some humans and could plausibly qualify as persons in the descriptive sense. So the equation of personhood in the descriptive and in the normative sense can only be maintained by invoking the fiction that all and only human beings are rational beings. By resorting to this fictional identification of humans and persons in the descriptive sense, the already anthropoid concept of personhood metamorphosizes to blunt speciesism and preserves a self-privileging mechanism which is yet purportedly based on the exceptional rational nature of the human species. Correctly, rationality ought to be assessed on an individual and not a generic basis, which would result in the morally undesirable and legally unthinkable consequence that some human non-persons in the descriptive sense would fall outside the scope of normative personhood. So rather than holding on to this untenable equation of personhood in the descriptive and in the normative sense, the idea of a necessary nexus must be abandoned in favor of a distinctly normative understanding of legal personhood. So, seeing that descriptive personhood cannot constitute a necessary condition for normative personhood or legal personhood, what remains is humans equals persons N equals rights. Yet the claim that being human is a necessary condition for qualifying as a person in the normative sense is again simply not true in law. seeing that non-human entities like corporations and sovereign states, etc., are legal persons. So this claim can be rejected without even touching upon the obvious speciesism this claim relies on. So finally then, what we are left with is the tautological affirmation that persons n equals rights. Who can be the beneficiaries of normative personhood remains open, whereas the claim that only rational beings or humans can be legal persons cannot be sustained. Dismantling legal personhood from its flawed anthropocentric and ratiocentric constraints facilitates the transition to understanding legal personhood as a normative concept, which could be applied to animals in principle. Okay, so far I have established that animals cannot be denied legal personhood on the grounds that they are not rational human beings, but I have not yet positively shown that they actually can be conceived as legal persons. So, considering that normative personhood is by definition inextricably linked with having rights, being a person in a normative sense isn't actually a prerequisite for being a right holder, but rather its interchangeable equivalent. So the question of whether animals can be conceived as legal persons can now be approached from a different angle. If animals can have legal rights, they automatically can be legal persons. So the question is now, are animals the kind of beings to whom rights can be reasonably ascribed to? A will theory of rights, which requires agency from right holders, will give an answer in the negative. However, will theory can be dismissed as the sole foundation of legal rights on the same grounds as rationality has already been dismissed, considering that humans who lack agency are clearly right holders under law. I would also like to point out that the inability of animals to bear duties does not in and of itself preclude them from having rights. Although rights, or more precisely claim rights, necessarily correlate with duties, it is a common misconception that a right holder must also be able to hold duties. As Matthew Kramer has noted quite accurately, except in the very unusual circumstances where someone holds a right against herself, someone's possession of a legal right does not entail that someone's bearing of a legal duty. Rather, it entails the bearing of a legal duty by somebody else. Okay, so then according to an interest theory of rights, the essence of a right is to protect the right holder's well-being. In its most basic understanding, rights are legally protected interests. For animals to qualify as potential right holders, two requirements must be met. Firstly, animals must have interests and a well-being. And secondly, the promotion of those animal interests and the well-being of animals must be of ultimate value. Both these requirements are already fulfilled in existing animal protection law, which is based on the recognition of animals as having interests which are worthy of protection for their own sakes. So animals thus clearly qualify as potential right holders, and existing law remarkably already entails the necessary conditions to realize this potential. So then, to conclude, animals can have legal rights and thus can be legal persons, and there is no cogent reason that prevents the law from recognizing animals as such. So this definitive finding leads me to some final remarks. So seeing that identifying legal personhood with humanity or centering it on rationality is untenable, the prevalent notion that animals must be human-like, rational beings in order to attain legal personhood is misplaced from a legal theoretical point of view. Legal personhood is not an ontological characteristic of certain beings, but a continually evolving legal construct which can be applied to animals, irrespective of their cognitive abilities. Yet the debate on animal personhood mostly revolves around demonstrating some animals' human-like rational qualities. These similarity approaches operate with a misconception of legal personhood and confine its normative scope to human-like animals, even though this is unnecessary from a legal theoretical point of view. More importantly, this is not only useless, but, as I would argue, detrimental to the vast majority of animals who experience the horrors of institutionalized animal exploitation, as it facilitates their continued exclusion from any meaningful legal consideration. So while a privileged class of humanized animals, most commonly great apes and cetaceans, are bestowed honorary human status, most animals remain relegated to the status of animalized, truly non-human animals. So playing the game of which animals are most like humans reinforces the anthropocentric notion that personhood is essentially a tribute to human exceptionality, and that rational humans are the norm around which legal personhood is erected, which is the key to the animal's exclusion in the first place. Similarity approaches do not disrupt, but rather build on the human-animal dichotomy, which inevitably leads to the valorization and superiority of humanness, and by extension human likeness, and the devaluation and inferiority of animal difference. In my opinion, animal personhood can and should transcend the traditional human-centered concept of personhood in order to accommodate and appreciate animals' otherness in a non-hierarchical way. So finally then, it is time to break open the Tertium non Datur, the dualistic rule in law according to which animals must be legal objects, seeing that they are neither natural nor juristic persons. Animals are not objects, and the ethical principles to which current animal protection law subscribes to already mark animals as quasi-subjects. I cannot get into this due to lack of time, but I am mostly alluding to the concept of dignity or inherent value of animals, which is already recognized in animal law, and the formal emancipation of legal thinghood, which I think in the US hasn't yet taken place, but for example in Switzerland and Germany has. And most notably the recognition of animals as holding interests which are worthy of protection for their own sakes. So these ethical principles are indicative of a paradigm change towards a status of animals as law's subjects. Animals are neither artificial entities nor human, and yet they don't have to be. It is time for the law to acknowledge that there is and can be a third, the animal person. Thank you.